This is an appeal in the matter of Cadent Gas Limited and CityFibre Limited.
Yes.
My lords, as you know, I appeal on behalf of CityFibre, the appellants in this court, respondents to the Section 67 arbitration. Which is an appeal. My learned friends, Mr. Liddell, King's Counsel, and Mr. Sully, appeal on behalf of Cadent,
Yes.
who are the respondents in this court. This appeal raises a short point of statutory construction. Whether under the New Roads and Streetworks Act 1991, a statutory undertaker, such as CityFibre, when he makes a claim for recovery of expenses incurred in making good damage to apparatus resulting from the execution of street works by another undertaker, is subject to statutory arbitration. And the issue relates, a number of it lies in section 96 of the 1991 Act and section 96(3) specifically of the 1991 Act.
Yes. Well, you can take it that we've all read the papers. We know what the case is about, and you can really launch straight into your submissions.
Very good. Well, I was going to say a word about the context in which this arises, but in the light of the indication, I shall not. It's all been said, both in writing by the judge and in the skeleton. So you know how we get to be here, and we can go straight to the issue at hand.
Thank you.
And the issue at hand requires us to look at section 96(3). I was going to invite my lords to look at it in the authorities bundle. Authorities 1, tab 2, page 95. I know it appears in various places in the papers, but I'm using it here because we're going to look at other parts of the statute which are in this section. I hope that's convenient. I just wanted to make just remind ourselves of the provisions. I'm sure the court is familiar, and then put forward a number of propositions which we say follow when we construe this section. In terms of matters just to look at on the section, heading recovery of costs and expenses, so that's the subject matter. 96(1) is of some importance in that it gives rise to the right to recover administrative expenses as well as the costs of incurred in carrying out works, and it is clearly reflective of and limited to a particular type of case, those to recover costs and expenses. But I think we can focus specifically on 96(3), and then specifically in that regard, my lords, 96(3), I just want to highlight certain language as we go through, where under any provision, so any and provision, important, a person, so that's as broad as it can be, is entitled, and I will focus on the broad breadth of that language, and then it says, in certain circumstances, to recover costs or expenses incurred by him in executing works, which is what we're concerned most with, but it also includes all the taking of steps. And in those circumstances, any dispute as the existence of those circumstances or the amount shall be determined by arbitration. And the real issue before my lords is whether our claim falls within that provision, or whether, because as the provision goes on, you say it applies whether the provision is expressed as conferring a right to recover or recover, or as imposing a liability to reimburse, or indemnify, or bear the cost. And then the passage which perhaps we'll spend the most time on, but does not apply in relation to a number of categories. A provision expressed as providing for the charging of a fee, that's one. The second, which we will be most concerned with, conferring a right to compensation. And then the third is in relation to section 78, which as we're told and we will see relates to the contribution of costs for making good long-term damage to the street. So those are the three situations to which the requirement of statutory arbitration does not apply. And at heart, the issue for my lords is whether a claim under section 821B, which is the claim we're concerned with, falls within the does not apply, and most specifically, whether it is to be treated as a provision under a provision conferring a right to compensation.
Expressed as, I think you accept, don't you? Expressed as covers all three of those categories.
Indeed. So with that reminder of the provision, which I suspect, my lord, you had in mind, I just wanted to start with a number of submissions, propositions, which we say which the court needs to bear in mind. The first is this: whether a dispute is subject to arbitration depends upon the provision on which the claim is founded. We see that straight away. Subpart 3, it opens with the words, where under any provision of the Act. So we're looking at the provision on which the claim is founded rather than the substance of the claim itself. The second proposition is that we are concerned here with provisions which specifically confer upon a party an entitlement to recover expenses incurred in executing works. It's not sufficient that we need to focus on the provision, but we also need to be confident that it is a provision which provides, we say, as a specific right to recover the cost of expenses incurred in executing works.
Or taking other steps.
Or taking other steps, you're quite right. I focus on executing works because it's the world we're in, but you're quite right. It would extend and therefore can legitimately be tested elsewhere in the statute, as including those passages. So we say that it has to be a provision that provides that specific right. But once it's a provision providing that specific right, what's clear is it applies to any provision providing that specific right, because we see the word, it's the third word of subsection 3, when under any provision.
Well, except for the proviso.
Well, subject always, my lord, to the meaning of the proviso.
Because that relates to a provision.
Well, we'll come to the debate on this, my lord, but the debate really turns on whether the proviso is taking out of the first. It relates to claims on provisions which would otherwise have fallen within the first sentence, or whether in fact it just identifies claims which do not fall properly so called within the first sentence, but may be mistaken for it because they are similar types of claim.
Yes, as I understand it, your argument below was that the proviso was a carve-out, but your argument in this court is not to that effect. You say that the proviso is dealing with a separate category from those that are within the first part of the clause, and that a claim can't be both. Have I understood your submission?
You're right to understand my argument before this court.
Yes.
Whether I was saying something different below may depend, but it's certainly how the judge characterises my argument. So for the sake of, it doesn't matter, I think, to dwell on precisely how it's put. That's certainly how it's characterised. But certainly before this court, my submission is that this isn't a carve-out. It isn't a carve-out in the sense that the judge uses that expression. It's a qualification, but it doesn't remove from the first sentence of 96.3 claims that would otherwise fall within it.
They're dealing with two separate subject matters. A claim can't be, I think, on your submission, both within the first part, which submits it to arbitration, and also within the proviso, which takes it out of the scope of arbitration.
Well, we say it is not, whether it can't be, but we say it is not on its true construction, which I suppose adds up to the same point. Yes, it isn't, it can't, therefore can't be.
And that must, I'm so sorry, and that must apply not just to the particular circumstances of this case, but any claims which can be the subject matter of 96.3, presumably.
Indeed, it's legitimate to test this against not simply the facts of this case, although the facts of this case will reflect very many, but others that might legitimately fall within 96.3.
Yep.
And that requires this court to take a view, I think, of the scope of the first part of 96.3, on which the judge, and I think my learned friend, contends for a very wide scope, effectively the contention that all and every provision, so-called enabling provisions, fall within it. Whereas I contend, with the submission I just made, that it's confined to provisions which provide a specific right to recover expenses rather than all enabling provisions.
Forgive me there, just to understand. the second part starts with this applies whether the provision is expressed. That must be referring to one of the any provisions in the first sentence, mustn't it?
Indeed.
Because it's this applies.
Indeed.
So that sentence is referring to the any provisions. This applies whether the provision is expressed as, etc., how it's expressed, but it does not apply, i.e. This does not apply in relation to a provision. So again, a provision must be one of the any provisions, mustn't it?
Well, my lord, for reasons I'll come to, we say read as a whole, no. It doesn't have to be one of the any provisions, and it doesn't have to be a provision entitling the recovery of costs. What it's saying is, really, when one looks at the provisions under Part 3, provisions that confer certain rights, let's use the language more precisely because then it's important, are expressed as conferring certain rights or liabilities, fall within scope of what I'm going to describe as 96.3, whereas other provisions, two of which are more accurate, more independent and clearly described, that's the fee and the section 78, and those which are expressed as conferring a right to compensations fall outside it. And obviously one of the points I need to persuade your lordships of is that there is referring to provisions in Part 3, but not something that would naturally fall within the first part of the first sentence. And the two, that is not a link, there's no necessary link as a matter of construction back to the any provision.
I'm just struggling at the moment, though, as a matter of language, because it seems to me that you have this concept, as you rightly identify in the first sentence, of a provision under which a person is entitled to recover costs or expenses. You then come to the second sentence. This applies, that is that first sentence. So we're dealing with a provision which entitled you to recover costs or expenses. So the provision and a provision are provisions which entitle someone to recover costs or expenses. So as a matter of language, I don't see how you can say that the carve-out or the proviso is not relating to, not excluding some certain of the provisions which entitle parties to recover costs or expenses.
Can I come back to that? I'm conscious of my lord's point. Can I develop my submissions? And
Well, I understand, but just simply as a matter of language, do you accept that's right, or do you say it's not right?
I don't accept that the reference to a provision in the proviso is necessarily a reference to a provision in the first sentence, even as a matter of language.
Can you explain why not?
Yes, because first of all, it's a provision as opposed to the provision. Secondly, as a matter of, you have to read the whole of this subsection together. And what the subsection is doing in my submission, well, I'm conscious the question is about language rather than purpose. So I'm trying to focus on that. As a matter of language, this is not words, but does not apply to a provision. It's not necessarily a reference back to one of the.
But it must be, mustn't it? Because we're talking about this, and this is provisions that entitle to recover costs. So if you're saying it's not referring to one of those, then of course this doesn't apply because it isn't one of those. So it only has any meaning if you're talking about any provision under which a person is entitled to recover costs or expenses.
Well, as we will see in my submission, the other two matters which are the subject of the does not apply, the proviso, are not in my submission on any sensible view. Provisions entitling the recovery of costs and expenses. There is no sensible way you can reach that conclusion. And if those cannot be, it must follow from that that the reference to a provision is not cannot necessarily be read, or must not be read, as referring back to the first sentence, any provision. And so when one sees the passage as a whole, the language takes on a slightly different colour to what it may do on first reading, and obviously it has to my Lord or Justice Phillips. So my second proposition, I'm sure you have it, my lords, but we say the any provision relates to provisions which specifically confer a right to recover costs and expenses, of which there are a number in this statute, and we don't need to go through them, but there are a number, irrespective of what the status of section 82(1)(b) are what the first sentence is directed at, and it may, and that's a core difference between the parties. In that my learned friend's approach is to say that all claims by all so-called enabling provisions fall within it. So I will come back to that. The third proposition I make is that the language of the first sentence of 96(3) expresses a clear intention and purpose. Where disputes arise as a result of a claim under any provision where a person is entitled to recover costs or expenses in the prescribed circumstances, they will be subject to arbitration and must be subject to arbitration.
How does that help you? The proviso shows an equally clear purpose that whatever falls within it is not subject to arbitration.
But as I indicated, I think the issue for this court, my lord, will depend on construing the scope of the proviso. When you come to do that, the underlying purpose, the wide purpose, we say, any provision, should be borne in mind when doing so. You'll have to decide whether you have the kind of clarity of language which may be required, which would to justify effectively qualifying the purpose, widely identified in the first passage. So my point here at this stage is that the statutory language at the start of subparagraph 3 suggests that makes clear mandatory arbitration in disputes arising in cases of this kind. And one can see why that might be. Cases of this kind are very likely to be cases about quantum, were costs incurred, how much. They're likely to be, in most circumstances, relatively straightforward, and one might say ripe for arbitration. And if Parliament has an intention that cases of this kind should be subject to arbitration, and if, as I'll come to, I can persuade you that on their face, claims under 82(1)(b) are just such a claim, claims of exactly this character, the question then arises is, well, why would Parliament have taken out of the regime just carefully circumscribed a claim of exactly this character? And to which, as far as I know, there is no sense, no one suggested there's a good reason why these claims should be treated differently, why the sorts of issues which make every other type of claim suitable for arbitration, but not this. So I'm then left by saying, well, has Parliament used language which is sufficiently clear, bearing in mind that all-embracing purpose for this type of case, to reach the conclusion that one of the very type of cases which it says must be arbitrated does not have to be. Which may just be another way of saying, my lords, is the language of the proviso clear enough, when read in context and as a whole, bearing in mind that underlying purpose. I hope that's a clear enough answer to my Lord Justice Popplewell's questions that do say it helps.
Thank you.
The next proposition we'd say is that the question of whether a provision is one that entitles the recovery of costs and expenses is one that should be determined by looking at the whole of the provision in question. In this case, it would be section 82(1)(b), but it could be for any other such claim. The effect of all of the language of the provision is to give rise to a specific entitlement to recover costs. Then it is within section 96(3) and not within the proviso. And it doesn't matter whether a particular verb has or has not been used. One looks at all of the language, takes all of that and says, what is the effect of the statutory language? So a provision can be expressed as conferring a right to recover expenses or a liability to reimburse in respect of expenses incurred, even if the words recovery or reimbursement are not used as part of the statutory language. If that is the effect of the provision, that is what the provision is doing, and that is what it is expressed to do. To go back to the language of 96(3).
Is it a necessary part of your case that one has to read into the first sentence that it's referring to a provision under which a person is entitled in certain circumstances to recover only costs or expenses?
Well,
in other words, if it is a claim in which your costs and expenses are part of a damages claim for compensation, I think, but tell me if I'm wrong, it's a necessary part of your argument that that never comes within the first part of the clause at all.
My lord, you are right. That is my argument. I was reflecting on the question whether it's a necessary part of my case that the word only is in. I certainly submit that the language of the first part of 96(3) is designed to identify claims that specifically identify a right to recover expenses that have been incurred, either because of executing works or taking other steps, and is looking at and therefore identifying provisions which have that specific effect. It is not identifying provisions where claims may be formulated, which could, as a matter of substance, look very much like them and could add up to a claim for recovery expenses, because it is their loss as a matter of damages, sometimes because that's how damages are assessed, sometimes for other reasons. But yes, it is a necessary part of my case. It is my case that is a reference. What we see written there is a reference to the very many provisions of the statute that do precisely that, but only that.
Thank you.
I understand.
Yes, well,
In relation to 96(3), provision which entitles someone to recover costs or expenses incurred. If we take, for example, 72(4), on page 55, that is an example of the street authority where it undertakes works because the undertaker has failed to do so, and they're causing a danger. The authority may carry out the necessary work and recover the costs. That is a case where, that is an example, isn't it, of where a person is entitled to recover costs or expenses incurred for executing works, but it's not a claim for compensation.
Yes, it is. I agree with that.
So
I agree with that proposition.
So that is the sort of the sort of provision which clearly, and you don't dispute, falls within the arbitration requirement.
Quite right.
So
Don't dispute that.
so we can see that there are provisions here which fit in to the first the non-carve out, which are not expressed as compensation and aren't compensation.
there are many others, but this is a good example.
Yes. So doesn't that make it quite easy for us then to see that what is being done here is saying, well, if there are other provisions which provide for costs and expenses, but which do say they are compensation, then they're not arbitrable. Isn't that quite straightforward in that case?
Well, my lord, back to the submission I made a moment ago, whether a provision effectively is doing the same thing as 72(4), saying you have any incurred costs and you're entitled to recover them, or is better described as a right to compensation, will depend upon looking at the relevant provision and what its effect is. And in my submission, it won't be driven by looking exclusively at the verb that is used, whether the verb
But that's the way that
compensates
the
is
act. But that's the way the act shows the distinction. It's all about how it's expressed.
Well, that, if I may say so, my lord, that assumes that the case against my argument, I should be submitting that's not the key to understanding the way the Act operates. But the key to understanding how the Act operates is to understand that what the Act is concerned with is the substance of whether a claim is or is not a claim for the recovery of expenses, and nothing, and no more than that. If so, as my Lord Justice Phillips says, as in 72(4), you're in arbitration. And my submission is 82(1)(b) is precisely the same type of provision.
Well,
And
we
the
know,
only thing that makes it-
we know that the Act is concerned to say that it doesn't matter whether it's expressed as a right to recover or imposing a liability to impose or indemnify or to bear the cost. So it is looking there at how it's expressed and saying how if it's expressed in any of those ways, it doesn't matter. But if it is expressed as compensation, then it does matter.
And that, if you like, comes back to the central issue, which is what does right to compensation mean? Because that's the language expressed as a right to compensation. And whether the answer to that is to be found simply as if the verb compensate is used anywhere in the provision, that overrides everything else. So it overrides the fact that, as I shall submit, 82(1)(b) is otherwise falls clearly within the first sentence, however narrowly one construes it, but it is taken out of it by the use of the verb, which I accept is ultimately what the judge found. The question is whether, the question for you on this appeal is whether that's right or not. But I understand the point against me, my lord.
And it is to do, just following on from it, it is to do with the way it's expressed.
Yeah.
That's the statutory concept. It's not to do with, it doesn't seem to be to do with asking yourself the sort of abstract question, would I consider this to be a compensation claim or not? It's saying, how is it being expressed in the provision? And where the provision says that the undertaker shall compensate, how can it then be said that that's not a right to compensation, expressed as a right to compensation?
Well, if I may, can I come to that in turn? Because it's, and I would like to have built the building blocks of how we get there rather than, but I am acutely aware that is the fundamental issue. My submission will be the use of the verb compensate of itself does not convert something which is otherwise very clearly a claim under a provision entitling the recovery of expenses for the execution of works into something, into a right of compensation.
If section 81(b) said there shall be a right of compensation for, would your argument be different?
It would be more difficult. I would recognise that straight away. And
Because that would come fairly and squarely within the terms of the proviso in terms of what it is expressed as.
I recognise that the case against me is, well, why is the use of the word compensate any different? I recognise that.
Yes.
So I am aware of that.
Deal with that now or in due course?
Well, I would prefer to deal with it as in my course because it's important. My contention will be that the right to compensation, the proviso, if you like, includes 3 items, 2 of which are demonstrably not carve-outs from the first sentence. Because they are demonstrably not carve-outs from the first sentence, that should give the court a clue as to whether the 3rd item is in fact a carve-out, or whether the words right to compensation, which is not a defined term, but it is expressed as such, is something which is to be governed, which is something which is a carve-out and is therefore different to the other 2 items. And it's in that context one should address the question of what right to compensation. And we say that in those circumstances, the right way to construe right to compensation suggests it's something which doesn't operate as a carve-out. Now that leaves over the question at the end, well, why did the draftsman use the verb compensate? And I understand that argument, at which point, in the end, my answer will be, well, I don't know, the draftsman used the verb compensate.
The person, even.
The person.
Is there a provision which does use the phrase right to compensation?
No.
So the Act, when it refers to that, it must be referring to something in
Indeed.
the Act.
Indeed, it must be. I recognise that, and at rock bottom, we will say it's where the rights conferred by a provision goes wider than simply the recovery of expenses incurred, and allows recovery for what one might typically call more general loss of damage. So that's consistent with how the word compensation is more generally understood.
But if one party is expressed as having an obligation to compensate another party, isn't the corollary of that the second party has a right to compensation from the first party?
Now, as I said, I understand the point against me, and I understand the way it's formulated by the judge, and we say that read in context, right to compensation does not have that meaning that has been put forward, but as I say, I'm aware of the point.
Yeah, perhaps we should let you develop it as you wish.
Yes, but I'm acutely aware, A, of what the judge's reasoning is, and B, the concerns that have been expressed by. I'm aware of those, and I'm also aware that unless I can persuade you of the merits of the contrary argument, you see some force in that. Let's put it as neutrally as that.
Yes, and when you come to it, you'll deal with the point that in relation to an 82(1)A claim by a street authority, compensate does mean
Indeed.
conferring a right to compensation.
Yes.
In the sense envisaged in the proviso, because it goes beyond costs and expenses.
Yes, and that's the context. But you have a
Deal with that in due course. Take your own course.
No, but it's very helpful to understand the matters that that's important. I do hope I managed to cover them as effectively as I'm able to. So I said that in the proviso, the language, I was at my 6th proposition is the words "but does not apply."
I may have missed your 5th. Which was your 5th?
No, you didn't miss my 5th. I'll deal with what was. I have got them out of order in my submission. This is my 5th now.
Right.
Now, the proviso, if I can call it that, and I think that's a neutral word for it, passage that begins but does not apply. My submission identifies claims that do not fall within the first part of subsection 96(3). We've covered that ground. Now, it's helpful, I think, to just look at the matters which do fall strictly within the proviso, which are identified in a way that there is no doubt about it. First, that is a claim in relation to the charging of a fee, and that is, take 65, in the authorities fund, but section 75 we can see. So this is the provision in relation to inspection fees. It provides that the Secretary of State may make regulations requiring an undertaker to pay a prescribed fee in respect of all inspections carried, such inspections that may be prescribed. And I don't think we need to go through the rest balance of the provision, but the effect of the provision is that a fee should be paid in respect of inspections that are undertaken or are prescribed, 1A or B. And in my submission, that is a provision that provides for the recovery or entitlement to recover a fee, but it does not recover, there are no circumstances in which it could be described as a provision which entitles one to the recovery of costs and expenses incurred by taking steps.
Well, is that
A fee might be
is that right?
A fee might be proxy for costs and expenses, but whether it is in fact a cost and expenses is a different thing.
Is this just for street authorities?
Indeed.
And the street authority has to pay a fee for the inspection, so it is in one sense a cost or expense which the street authority has to bear.
Well, the street authority undertakes the inspection, and the
Sorry.
undertaker,
The undertaker. I got it the wrong way around. The undertaker has to.
the undertaker has to pay for the inspection provided, such as services provided, as in relation to, and then all inspections carried out of his street works or such expenses as those works as may be prescribed. But what they pay is a fee, and a prescribed fee. They don't pay for the costs incurred by the street authority. They pay a fee. And when we say that's a different thing, it may be providing some kind of compensation for, value for, remuneration, consideration, whichever language one wants to use, in return for the services provided, but it is not a right to recover costs and expenses incurred. It's a right to recover a fee. And that fee, there's nothing to suggest that fee is to be prescribed based upon the precise costs and expenses incurred. It's a prescribed fee, prescribed at a particular rate. So we do say, not easy to see how that is a provision that can be described as one entitling a person to recover costs and expenses incurred for undertaking works or taking steps. It's something
Well,
similar,
forgive me,
but analytically different.
Forgive me. The street authority has to carry out steps.
Yes.
That is inspections, which obviously will cause it to incur cost. And then the regulation may require undertakers to make payments in respect of inspections anticipated, etc. And different provisions for different payments for different descriptions, etc. Different fees by reference to the nature, etc. Now, if it could have been argued that is expressed as a right to recover or to bear the cost of those steps on the part of the undertaker. This is clarifying for the avoidance of doubt that if it's expressed as charging a fee, it doesn't fall within the first sentence.
My contention is simply that read appropriately and fairly, section 75, which is the only reference to fees that we've identified, cannot sensibly be regarded as a provision which would fall within the first sentence of 96.3.
Well, it could certainly be regarded as a provision in which it is sensible for the avoidance of doubt to make it plain that it does not.
I don't dissent from that. It may well be sensible for the avoidance of doubt to say the first sentence of 96.3 is actually quite narrowly defined, such that something like an inspection fee is not within it.
But why is it necessary to say anything about it at all in 96.3?
Well,
The default position is claims are not required to be arbitrated. If a statute says nothing about them, there's no requirement to arbitrate them. So if just take this one for the moment, if nothing was said about this in the proviso, your case would be nothing needed to be said because it never came within the first part of the clause which required statutory arbitration.
well, certainly if it was necessary to engage with that question in this context, I would be saying it isn't within it.
So why is it being mentioned at all?
It's being mentioned here because the passage in the proviso which is relied upon and is the sole basis for saying that statutory arbitration does not apply in this case lives alongside these two other examples, the fee and the contribution to long-term damage, which we say are not in any sense matters that are within the scope of 96.3.
I understand that, but the point I'm putting to you
Yeah.
is, if you're right that you covered at my lord's point that this was clarificatory of something which might be regarded as a cost or expense within the first part, but is taking it out of that, making clear that it's taken out of that. And your answer was, well, it's never within it on a proper construction in the first place. And if that's right, you wouldn't need to say anything about it in the proviso. I think that's the point I'm putting to you.
I follow that point, but it may not be. It's perfectly good sense to understand that Parliament may have felt the need to make clear the limits of the statutory requirement by identifying where the limits lay and by clarifying that things which may be capable of being understood are not within it. So I wouldn't be saying as a matter of on its true construction, if those words weren't there, it was somehow in it. But I would be saying that there's a perfectly good reason why Parliament might want to make clear the types of claims that are without, and they're without because they always were without. But and as we see, Cadent in this case, and we've seen in other cases, parties have sought to suggest that things fall within 82(1)(b), which the courts have said subsequently they don't. So in those sort of circumstances, there may be a perfectly good reason why Parliament has sought to say where the limits of statutory arbitration lie. So we do say it's clarificatory. We do say it's there to identify the limits. But I don't suggest that if those words weren't there, it would otherwise be it.
And how does this sit with your submission about the purpose of what is and what isn't arbitrable? One might have thought that a dispute about whether you can recover a fee which is going to be prescribed in amount was the simplest of all possible claims, which on your submission would put it firmly within the kind of category that you would expect to be arbitrable.
Well, I think we need to derive the purpose from the statutory language. As much as it may or may not have made sense to include a claim like this within the scope of the first sentence of 96.3, in my submission the statutory language isn't identifying those kind of claims, it's identifying a different category of claims, which my Lord Justice Phillips identified in one in section 72, but there are many others in the statute. And that's where the statutory purpose is identified. Well, since this doesn't fall within that purpose, because it never did, because Parliament have chosen to define the purpose in relation to claims where for the recovery of execution of works or taking steps, well then this was never within it, so it doesn't undermine the purpose. And irrespective of whether objectively viewed, others may say, well, would have been a good idea to include that as well. They haven't. So therefore, that purpose is not undermined.
But then it just seems to be a matter of construction of the provision. So Parliament seems to be looking in two directions. Some claims are arbitrable, some claims are not. Parliament must be taken to have the purpose, if you could put it that way, the intention of not including some claims because it says so. And so you've got to then look at the words to work out which purpose applies to which kind of claim. So then it's hard to see how purpose really assists,
Well-
because you're going round in a circle.
Well, in short, we say that we will come to look at this, but I'm sure my lords have it in mind. Claim under section 82(1)(b) is as a matter of substance a claim which is limited to a claim for the recovery of costs incurred for executing works. It is nothing more and nothing less than that, and it can never be any more or any less than that. As such, we say it does fall, unlike claims about charges and fees, squarely within what appears to be the breadth of the first sentence of 96(3). In which case, we say, the court should need some assistance as why it would be, having defined the intention and purpose in a very specific way, and having identified that purpose, it would then, using very, we say, not precise or specific language, exclude an important, perhaps even likely to be a very large number of those claims by the use of the expression right to compensation. So we do say it helps at this stage, it helps in understanding what kind of language maybe is required to carve out, if I can use the judge's language, a number of claims which would otherwise have fallen within. And I don't say it can't be done. Parliament can decide, of course they can decide, to say, well, although we say all of these claims should be subject to arbitration, there's an exception for this type of claim. Of course Parliament can do that. And if they do that with sufficient clarity, well, they've done it. And I don't suggest otherwise. The issue is whether they've done that with sufficient clarity here, and therefore whether that the right construction is the one that the judge said.
But I think my point to you is, what do you suggest from a purposive point of view are the relative merits of arbitration on the one hand and a claim in the small claims court so far as a section 75 inspection fee are concerned?
Oh, all the same considerations would apply.
Sorry?
I understand. If you were looking at the sorts of factors that would say that this type of thing would be suitable for arbitration, I don't dissent that a claim under section 75 would be equally suitable for all very similar reasons. I'm not suggesting there's anything about the nature of a claim under that section which makes it any less suitable for arbitration.
But that does rather reinforce my lord's point that we're not really able to get much out of any recourse to arguments about the purpose by reference to the nature of a section 81 claim compared with the nature of, let's say, a section 75 claim. Parliament has actually chosen to put one, you say, in the arbitrability box.
Yes.
The other, all agreed, not in the arbitrability box, and yet the same sort of considerations from a purposive point of view might apply. So we've just got to look at the language, haven't we?
I accept that the language is going to be obviously the key feature, and in the end, that will dictate the course that this court takes. And I'm not suggesting that you should do anything other than that.
May I suggest to you that the position in relation to fees may be a bit more complicated, because you see that section 75(6) says that nothing in this section applies to inspections in respect to which the undertaker is obliged to bear the cost or pay the prescribed fee under 72(2). And if you look at 72(2), it's that where an undertaker has failed to comply with his duties with respect to reinstatement, he shall bear the cost of a joint inspection, an inspection of remedial works, an inspection where they've been completed. So that is a liability to bear the cost, which prima facie comes within the arbitrability provisions. But then there also seems to be a prescribed fee.
Yes, and the proposition, my proposition, my lord, is that for example, a claim under 72 would be arbitrable, whereas a claim under 75, even if the proviso hadn't been there, would never be arbitrable because it is not a provision in respect of which a party receives an entitlement to recover costs and expenses.
But you can see, one can certainly see that if you didn't have this express reference to expressed as the charging of a fee, then one might well have said, well, what's the difference between a fee under 75 and charges under 72.2? Particularly because 72.2 plainly also includes a fee.
Well, but my lord, in my submission, the passage in 72 that is captured in the first part of 96.3 is the passage which gives an express right to recover the costs and expenses, whereas the rights to recover a fee, charge a fee, are things that fall outside.
But it's not. You have
Section
a right.
96.
You have a right to a prescribed fee in relation to inspections under 72.2, and we know that from 75.6.
Yes, but my proposition, my lord, is 72.4 that is the right that falls within section 96.3, the right to recover costs reasonably incurred by them in doing so. So it's that specific right rather than the right to a fee in section 72 that's within it. And back to, if you like, one of my opening submissions is that first part of 96.3 is clearly and specifically designed to relate to provisions which entitle the recovery of costs and expenses. It's not put any wider than that. And we say it's quite deliberate, and it's meant to require us to focus on those types of cases and not cases that give entitlement perhaps to a fee or a charge or a contribution, which are not properly analysed, the costs and expenses incurred in executing works or taking steps. And that, I think, takes me to the second of those falling within advisory, which is the obligations in relation to contributions to long-term costs. That's paragraph, that's section 78, which is at page 69.
Sorry, just on your first one,
Yes.
are those the only ones about charging a fee?
Well,
or are there
so
others?
we say yes, but my learned friends say section 74 also falls within it, so it's perhaps worth just looking at that. So save me coming back to any of this later. I've already written for me. Page 59. I'm grateful. (74) provides for the provision of regulations requiring an undertaker to pay a charge where effectively the duration of works take place for longer than a prescribed period, or they are not completed within a reasonable period. So this is the payment of a charge, and it perhaps it's helpful to look at subsection 5 on page 60. To see how the amount of the charge shall be determined. Now, we say that this is a provision which enables a charge to be levied for works taking longer than they ought to, and we can see that the charge grounds for the charge will be determined in relation to the time taken for the works. And that, but the levying party, the highway authority, it's not in those circumstances any sense recovering its costs or expenses. There is no sense in which you could describe that provision as having that effect. Now, for our part, we don't read the proviso in subsection 96.3 as referring to this clause. But my learned friends suggest it does, and moreover, they and the judge took the view that all of these provisions fell within 96.3. They were all enabling provisions fall, so this one would have to as well. And on the basis that everything is within unless excluded by the proviso. And we say, if you look at 74, that can't be right. 74 cannot be a provision that is within the first part of section 96.3 because it simply doesn't provide for the entitlement that the section requires. However one chooses to read it. But I do recognise that under section 96.3, the proviso of it, what's referred to is provisions expressed as giving rise to the charging of fee, which and this is not a fee, it's a charge, and they are, in my submission, different things.
Well, it's not expressed as a fee.
No, it's not expressed as a fee, but and moreover they are analytically different things. A fee tends to be for something you pay for services provided, whereas a charge, certainly in this context, it is almost like a penalty or a payment for overrun. So it's a different animal.
But it does suggest as well that the drafting actually is relatively careful, isn't it? Because it's picked up on expressed as a fee relating to 75, and it means expressed as a fee because otherwise it could be argued it encompassed a charge, and the answer to that is it doesn't because it's not expressed.
It's not my submission that this falls within expressed as a fee, but it is, as I understand.
Well, I think it's expressed as charging a fee, so that might have given rise to some.
Just as charging fee,
And this is a charge for what is to be a prescribed amount or a calculable amount
calculated
by reference to which might be thought to be expressed as charging a fee, but this makes clear that it's not.
Well, if this falls within, if this is being
I mean, it either is or it isn't.
if it's being referred to in 96.3,
yeah.
It's making it clear. If it is being referred to in 96.3, we would say this is another example of something that could never have been in.
But you say, but on either view, whether it is or isn't within the proviso, it's never within the first part of the clause at all.
Indeed, and that's the significance.
And why do you say it's being mentioned here then?
It's well for the same reason I gave. So I think the same question that was put to me a little earlier, my lord. We said in order to clarify the scope.
Yeah. So because it might have been thought that it fell within the first part of the clause.
Indeed. And so, and then so I think that was, my lord, just as well as helpfully directed us to look at that as well. And great. The other provision, before we get to right to compensation, that is expressly referred to is section 78, and that's at page 69.
Yeah.
This is the obligation of an undertaker to contribute to the costs incurred or likely to be incurred by the street authority in case of a road subject to a concession within the meaning of the Act. We don't need to bog down in that, but the regulations may provide for a contribution to the cost of a particular remedial works or for a general contribution calculated in such manner as may be prescribed. And we say in relation to that, this is something that gives rise to a right to claim for the street authority to claim a contribution. It can be a general contribution in a prescribed manner, and it can be claimed even though the works have not been carried out because they are works that are likely to be incurred by the street authority. So this is a provision which isn't conferring a right to recover the costs of work that have been executed. It's instead conferring a right to a contribution.
When you say the costs, that's not the language in the first line of
No.
subclause 3. It's simply to recover costs.
Costs and expenses.
Yeah.
Costs.
And this you say doesn't fall within that,
I do.
because a contribution, a right to a contribution to costs, wouldn't be described as a right to recover costs.
Well, recover costs incurred executing works or taking steps, and this gives rise to a right to recover a contribution even when those costs have not yet been incurred.
Well, it may do, but it also provides for an entitlement where the costs have been incurred.
Well,
Yes?
yes, but a contribution towards the entitlement,
Yeah, so
rather
you're-
than
Maybe 100%.
It may be 100% contribution.
it may be, but it may also not be. And
But also 96.3 doesn't refer to recover all the costs. It just says recover costs.
Indeed.
incurred.
no, I recognise that.
So why doesn't 78 encompass some recovery of costs for works incurred?
Because this is a right that arises in relation to long-term damage of roads in works of reconstruction or resurfacing of the road. It's a right to obtain effectively a contribution from undertakers, and it's a right that is driven at obtaining a contribution rather than specific costs for specific work that has been undertaken.
Do the regulations identify any particular aspects of those costs which are to be borne 100%?
Not that I'm aware of. I don't know the answer. I don't know the answer to that.
You don't know.
And you said just now that it doesn't relate to specific works, but actually subsection 2 says that the regulations may provide for a contribution to the cost of particular remedial works. And that has the flavour of a recovery of costs incurred in executing works or taking other steps. Now, it's true that it may also give more extensive rights than that because of the general contribution and so on. But at least that part of it looks as though it falls within the first sentence of subsection 3 of 96.
Well, it comes back, I suppose, to how one approaches this first sentence of section 96.3. Whether one approaches that as a subsect, as a passage that refers to not to a specific right to recover specific expenses incurred in a particular way, or whether it covers claims of more general kind that could include a right to recover certain expenses.
Suppose
If
that
it's the latter, well then obviously this would fall within it.
suppose that the Secretary of State made regulations which included a provision which said in the event of long-term damage caused by the undertaker, the undertaker is to bear all the costs of the steps necessary to cordon off the damaged area in the first 24 hours, let us say. That would be a lawful regulation under section 78.
No reason to suggest otherwise.
And that would then entitle the recovery of 100% of those costs.
In that hypothetical scenario.
And
that's
section
right.
78 would therefore be a provision which entitled a person in certain circumstances, i.e. those circumstances, to recover all the costs incurred in executing those works. But you say it still wouldn't fall within the rubric of the first part.
We say it doesn't because of the way in which the first part is formulated, but it may matter in my submission what matters for the purposes of understanding how to read the proviso is whether what's contained within the proviso are things that would otherwise have fallen within 96.
Right, that's the point we're on.
Exactly. And you've heard my submission in relation to this section. And I've also sort of been on we've looked at other subsections, and I've suggested that in relation to section 75 and 74, those are provisions which cannot fairly be regarded as provisions falling within the first sentence of paragraph 90, section 96.3. Now, if I'm right about that, that is a context in which one approaches the third of the three categories, which is the question of what's meant by a right to compensation. And we say that if it sits alongside at least one, and in my submission, two other categories which are not within the first part of section 96.3. Well, at least one suggests that the others are unlikely to be. It's a good reason in my submission to reflect on whether Parliament intended section 78 to be captured by it. And if Parliament did not have that intention, well then, in those circumstances, one looks at the expression right to compensation, which, as we've already been over, not an expression the statute otherwise uses or defines, and looks to see whether that alone, unusually, is one providing a carve-out from 96.3, given that the other provisions do not. We say the expression right to compensation has to be construed given its natural meaning, and in context. And the context in this proviso is sitting alongside other categories that are not naturally within the first part of 96.3. That context gives colour to the meaning of the expression right to compensation, and we say that should lead the court to conclude that that also is a provision which is a category which falls outside the first sentence. It is not a carve-out in the sense described as such, but it is something that is seeking to identify different and analytically different rights which exist in the statute, but are not simply rights to recover costs and expenses for executing work or taking steps. As you know from my skeleton, we say that what's being referred to there are rights to recover more general loss and damages, which one sees in a number of different sections. And I'll come to those in a moment, but that's how we say you should construe right to compensation. Now, we've covered a number of the points I was going to deal with, but hopefully I'll make sure I don't repeat myself when I summarise matters. But I'm keen to deal with the court's questions as they come, but also to try and cover the ground I need to cover. Can we just look now at section 82(1)(b), because that's the section we haven't, which is at page 75 in the same bundle. This is the claim, this is the provision under which this claim is made. And it's headed liability for damage or loss caused. And we see that 82(1), undertaker shall compensate, and I'll have to come back to that. And then we have two different types of claim that could be brought. A claim that could be brought by the street authority in respect of any loss or damage suffered by the authority in their capacity as such. So there's only one candidate there for who the claimant might be, but broadly formulated, or any loss or damage suffered in that capacity. And then B,
Just pausing there, does 82(1)(a) fall within the proviso as something which is expressed to be compensation?
I would accept that 82(1)(a) is expressed as a right to compensation.
And where in the wording do we find it expressed to be compensation,
Well, my lord, it
as
comes,
opposed to being compensation?
so, my lord, we say that compensation in this context, and I haven't come to this bit of my argument yet, but compensation in this context bears its natural meaning. Its natural meaning is recovery for loss that one has suffered, making a man whole. We've seen
That I entirely understand, and I entirely understand you say if you look at what follows little a, that is referring to something which is properly described as compensation. I understand all that, but we know that what the proviso says is that what is carved out is something which is expressed to be compensation. And where is a claim that falls within 82(1)(a) expressed to be as compensation?
My lord, my submission on that point, in answer to my lord's question, is that whether something is expressed to be something comes not simply from any single use of word, but looking at the whole of the language as a whole. It is then, if something as a language as a whole bears that meaning, well then it is expressed to be.
Well, which words do you say as a whole?
In respect of any loss or damage suffered.
But if that's
But you don't include the use of the word compensate then?
well,
I mean, your argument necessarily has not to, and I think your argument is it's the words that follow a amount to it being expressed as compensation because it's a claim for loss and damage, and any claim which is expressed as a claim for loss and damage is compensation, and therefore is expressed to be.
indeed.
And if that's right, why do you need the words expressed as in the proviso in 96(3) at all? Why doesn't it simply say claims for compensation?
Well, that may take us back to whether the words expressed as add anything significant. In my submission, they don't. My own firm obviously says differently, and that's in a sense. We say expressed as doesn't require the reader, whether it be this court or any other reader, to say I must focus on any specific particular word. As it says, well, what as an expression does this confer as a right? As a right, a liability, an obligation.
I understand your argument, but when we were looking at the second sentence, both in terms of what it says is included and what is not included, it's very careful to be phrased by reference to how things are expressed. For the first part of the second sentence, it's making clear that you still come within the first part, even if it isn't expressed as a right to recovery, and if it's expressed as a liability to reimburse or bear the cost of, and so on. And in relation to the second part, which we've been describing as the proviso, again, it's carefully worded as what is expressed to be one of those three categories. But you say, at least so far as compensation is concerned, the words expressed as are surplusage and shouldn't really be there governing compensation.
Well,
Is that a fair characterisation or an unfair one?
I'm not suggesting that the words expressed as surplusage in the sense that Parliament didn't have a meaning. What I am suggesting is you don't find the answer to what something is expressed by looking for any particular word or words, and therefore we do say that the use of the verb compensate in 82(1) does not answer the question whether that which follows is necessarily a right to compensation. As it transpires, 82(1)(a) on my submission is a right to compensation. It's a right to compensation because of the substance of what it said, but I recognise the word compensate is there so that the reader would be able to have it confirmed to them.
Have I written down your submission right, that in deciding whether something is expressed as something, you don't look at the particular words?
Well, one doesn't focus on any one particular word. You look at the particular words, yes, but don't look at any one particular word. You look at what the words as a whole, as a sentence, mean.
If you accept that a claim within a claim under 82(1)(a) could be a claim within the first sentence of 96(3).
Well, in my submission, it isn't. It couldn't be, no.
So it's not within the proviso.
No, well, it is within the proviso because it's back to the ground we covered. The proviso is identifying things that are not within the first sentence,
So you say
but
it's
are
only within the
but are
second.
clarifying things which might be thought to fall within it, but are analytically not within it.
So if they brought a claim under 82(1) and said, well, the head of damage we're recovering is the costs and expenses incurred by us in executing works, you'd say that wasn't a claim within the first sentence.
If a street authority under 82(1)(a) was recovering its loss by reference to the costs it had in fact incurred, I would accept that falls outside the first sentence.
No, but if the particular claim in question was simply a cost and expenses claim, so it was no different in kind from the same claim which was brought under 82(1)(b) by somebody who's not a street authority. So suppose two identical claims, one brought by the street authority under A, the other by someone else under B, and they are limited to what would probably be described as costs and expenses. You say, do you, that the 82(1)(a) claim by the street authority, limited to a claim for costs and expenses, would not fall within the first sentence?
I do, and the reason for that, my lords, is back to where I started. If you look at 96(3), it's concerned with not the substance of any claim, but the provision, the nature of the provision under which it is brought. And then, so you ask yourself the question, what is the provision, the enabling provision, which allows this claim to be brought? The enabling provision is one in my submission, falls into more than one category, but let's just focus on the ones that are important for the moment. Those which enable specifically the right to recovery of expenses for taking steps or executing works, those are within 96(3). Everything within that in the statute, any provision, falls within it. In
Sorry,
relation,
I'm just so sorry about that, but it doesn't actually say that it's expressed to cover only
no,
an entitlement to recover costs and expenses, because the first sentence of the first part of the second sentence broadens it out and says it doesn't have to be expressed in that way. It can be expressed in terms of a liability to reimburse, indemnity, etc.
well, my lord, I don't think the word expressed appears in the first part of the sentence, does it?
That's
The
right.
any provision is entitled.
Yes, well that's a difficulty for you, isn't it? Because you have to read a limitation into it, which is the only point I was putting to you earlier and came in my Lord's formulation a moment ago.
Yes, and
You're treating it as if it's something which is expressed as only entitling you to recover costs and expenses, whereas if it is a provision under which you are entitled to recover costs and expenses, amongst other things, which an 82(1)(a) claim may be, you say that won't do for the first part of 96(3).
and I do because we say that the focus is on the nature of the provision under which the claim is brought.
Not only the nature of the provision, but the provision must be one which expressly confines itself to a right to recovery of costs and expenses,
Yes.
or
Yes,
reimbursement or bearing them.
Indeed, and I've used the word specifically, and what I mean by that is gives you a specific right, express right, to the recovery of costs and expenses, as opposed to one that may be implied from, say, a claim for loss and damage.
And if it was said, well, in the second sentence, the draftsman has been very careful to use the word expressed to mean expressed when they want to. Why have they not used the word expressed in the first sentence if that's what you say it means?
It's not so much that I say it means that. My submission really is this: if the draftsman had intended to say any claim under any provision of this part shall be the subject of arbitration, effectively is what the judge held and what an earned friend contends for. If every enabling provision is within 96.3, well then such language would have been used. Why clutter the language with an expression that says, which in certain circumstances entitles? The effect of that means that effectively arbitration comes to embrace claims that are not simply for the recovery of costs and expenses, but will recover all. May, if they were not otherwise excluded, certain loss and damage claims, which would be different, and they would therefore be caught by arbitration. And what one finds, we say,
that's the other way around with respect. But that's not the problem, because claims which are for general loss and damage, like a claim under 82(1)(a), wouldn't, say a claim for lost profits or something, although it's difficult to see the authority losing profits, but something that goes beyond costs and expenses, well, they wouldn't fall within the first sentence. But this is the question here is the other way around. Supposing that the claim is for such costs and expenses, it may be for other things as well, but supposing it is for such costs and expenses, why isn't that a claim to recover those costs and expenses?
well, come back to the proposition that it depends the nature of the provision under which it is brought, and you have my submission. We say it needs to be specific. Lord Justice Popplewell says only, and that may be the effect of my submission, but it certainly needs to be specific in identifying the right. It must be expressed, not implied, and that ends up, if you look at the statute, up to the same result. And we say that is what's being referred to in the first part of 96.3, and not all and any claims that could, in some circumstances, all and any provisions that could give, in some circumstances, an entitlement to recover costs and expenses based upon perhaps a wider right to loss and damage, which may then be subsequently excluded. I follow that, but we're looking just at the scope of the first sentence initially, or perhaps other rights and liabilities under the statute. Well, then we say, if the intention had been to bring within that first sentence pretty much any claim within Part 3, that's what Parliament would have said.
Can I try another point on you? I know it's very tiresome. We keep
No.
firing questions at you,
It's
but
my job.
that's part of the process of our trying
Indeed.
to work out what the right answer is. But can I just focus on the words in 96.3, in certain circumstances? Now, one reading of that might be that we're looking at provisions which do not always entitle the recovery of costs or expenses incurred, but may do so in some circumstances. In other words, it's aimed at provisions which include a right to recover costs and expenses, but are not confined to a right to cover costs and expenses. Is that the right way of reading in certain circumstances?
My Lord, we would submit it is not the right way to read it.
What does it add then? How would your submission be different if it simply read a person is entitled to recover costs or expenses?
The effect of those words, my Lord, is intended to direct you to provisions which identify circumstances in which one can recover costs and expenses incurred, irrespective of whether you would have a general right to the recovery of loss. And so in each of the clauses, the provisions one looks at, there will be circumstances which are identified, which triggers the entitlement to the recovery of loss and expenses. And that is what is being referred to.
They're referring to the circumstances in the provision, which is a provision solely to recover costs or expenses.
Indeed.
But my question to you is, if that's right, and I think that is the effect of your argument, what do the words in certain circumstances add? If you struck them out, your argument would be identical. You don't need to say that the provision identifies certain circumstances when this is so.
Well, I think it's probably right that the argument would be identical.
So are they not surplusage on your argument?
Can I suggest, I don't want to do your job for you, but can I suggest an answer to that, which is that in the next line it says, any dispute as to the existence of those circumstances, which suggests that it's the triggering circumstances which are being referred to in the phrase in certain circumstances. So a dispute about the existence of those circumstances is one of the things which needs to go to arbitration. But that's a possible.
Yes, I'm grateful, my lord.
Yes.
That would certainly fit with the way that the submission I made a moment ago, that what it's identifying is the circumstances that in any given provision give right to the entitlement. And so in that sense, given the words that follow, they aren't, in my submission, surplusage, because it makes their reference, they refer, if you like, to the thing that comes later in the sentence, which is whether there's a dispute about whether the circumstances exist or not. And that might answer my lord's point.
It does. Thank you.
Could I ask you a different question? Going back to section 82, because I think one of your arguments for saying that 82(1)(a) is properly to be regarded as a provision conferring a right to compensation, whereas B is not. Is that reference to the idea of loss and damage in A? Now, if you go down to subsection 3 and 4, those subsections are qualifications of the liability, which essentially in the first place are saying, well, if someone else is responsible for it, if it's the claimant's own fault, then the liability doesn't arise. And secondly, if someone else is responsible, then that may also be a defence. That's a paraphrasing. But both of those subsections are expressed in the language of loss and damage, or damage and loss. And they must apply both to subsection 1A and subsection 1B, because these are defences to claims brought under both 1A and B. And it follows from that, it seems to me, that what's being talked about in B must be a form of loss and damage.
Well, my lord, I see my lord's point. I was going to come to this section and emphasise the use of the word liability, because liabilities is one of those words that's expressly within 96.3. But I can see that loss and damage is something that is referred to. And I also accept that the effect of 3 and 4. 3 effectively makes the liability strict. And 4 is the circumstances in which you may have a defence to what would otherwise be a strict liability.
But again, without seeking to do your job for you, I think your answer is you accept that an 82(1)(a) claim may include a simple claim for costs and expenses, but that doesn't bring it within the first part of 96.3, which is confined to provisions which are specifically and only for recovery of costs and expenses.
Indeed, that's right. But I understand my lord.
My point was a slightly different one with respect, which is
why do we see the words loss and damage here?
here.
If it's governing as it must do.
Well, if it's not a claim, not a claim conferring a right of compensation, because part of your argument for distinguishing A and B, as I understood it, where you accepted that A was a provision conferring a right to compensation and B wasn't was that A is expressed in the language of loss and damage, which you say is naturally to be regarded as a form of compensation, whereas B isn't. And my question is this: when you read more of the section, it's clear that B is itself being regarded as a form of loss and damage, because that's what subsection 3 and 4 talk about. They talk about damage or loss, and they clearly apply to both A and B in subsection 1. And so what I'm suggesting is that your distinction between loss and damage in A and the absence of those words in B doesn't take one very far in working out whether the claim is one for compensation.
And my lord, what I would say, I understand my lord's point. What I would say in relation to that is the references that one finds to, in subsection 3, to loss or damage, and subsection 4 to loss or damage, reflect the fact that there is encompassed within 82.1a a right to recover loss and damage. So one sees that word reflecting the fact that loss and damage is referred to there. So the language which one sees in 3 and 4, which is common to both, must be wide enough to apply to both 82.1a and 82.1b. And in order to make sure it's wide enough to apply to both, words loss and damage are included in there to reflect the fact that one's dealing in those circumstances with an 82.1a claim as well as an 82.1b claim.
Well, you have a simple answer to this, don't you? I think, which is that the word damage is in 82.1b because it's expenses reasonably incurred in making good damage. And so when you get in 3 and 4, whether or not the damage is attributable to negligence, etc., that's readily explicable by the fact that it is expenses reasonably incurred in making good damage.
Absolutely, and I was about to come to that, but I was just saying the use of the word loss and it reflects the fact of the scope of 82.1a, rather than use of just damage.
But the bigger point, which I presume you're going to come to, is the really big point is how you persuade us that compensating for expenses reasonably incurred in making good damage isn't compensation.
Isn't expressed as compensation.
Yes, or isn't expressed as compensation. And assuming you're going to come to that, because that seems to me is ultimately the really big question in the case.
Indeed, and I'm looking to see whether I just cut to that chase, if I may put it that way, because I appreciate that's what you'll find most assistance on. I was going to, but can I take it, my lords, that your lords are familiar with the relevant statutory principles of statutory interpretation? Would you be assisted by being shown the authorities?
No, I don't think we will, thank you, unless,
that's what
unless
I
hear
assumed.
any dissent on either side. We're very familiar with those principles.
That's what I assumed, and I didn't want to take up time on that if it was unnecessary. And now, I'm keen to get to my Lord Justice Phillips's bigger point, but to make sure I do so having covered the ground I wanted to cover before I get there. But I recognise I need to do that. I suspect I have done so, albeit in answer to the bench's questions rather than how I was going to do it. But that doesn't matter. You have the points I argue, which is all that really matters. So let me just summarise what we say. I think you know where we get to, and then I'll come to the point. We've looked at 96.3 at some length. I've made my submission about the nature of claims that fall within the first part of it. I've made a submission about purpose. You want to understand the point on purpose, but the issue, of course, is does it need to be read subject to whatever the proviso says, which may suggest that the purpose is more qualified, but my lords have that. My lords, you'll have seen, because we mentioned it in our skeleton, just developing the point about purpose a little bit more the issues that arise if this particular type of claim for expenses is excluded, and the particular problems that arise. You can see that the judge himself expressed concerns about whether these sort of claims would be more suitable for arbitration. There's some evidence about it, and this court on a previous occasion, and it's referred to in Skeleton, has expressed its own view on whether claims of this kind really ought to be in court or whether they should be arbitrated. Maybe I can just show you that briefly. It's at the same authorities bundle at tab 13. This is all in the context of the broader policy questions, and I recognise that the significance of those depends upon what you make of my submissions on the statutory language. But this was a decision in Yorkshire Electricity against Telewest, and it was a case where a claim was being brought under section 82(1)(b), or a number of cases, so-called test cases were being brought. And we don't need to go into any of the detail of that. I just wanted to show you two passages. First, at page 246, the judgment of Lord Justice Buxton, paragraph 3. And I'm not going to read it out, but I just think that if you haven't read it, I invite my lord to read it to yourself. And then the passage at page in the bundle 257 at paragraphs 46 to 48. And you will see that this court on that occasion was keen to make the point that in future disputes under this section shouldn't go to court, or the small claims court, as the judge had said. On the contrary, they should be dealt with by mediation or arbitration. Though, as is clear at 48, it's clear that the court did not feel that the issue of arbitration was not before the court on that occasion, that it could enforce that. Now, for present purposes, I simply...
Wait, weren't they just talking about the cases that they were dealing with? They're talking about the way forward for these claims. Between these parties, aren't they? They're not saying whenever there's a case under the section, it should never go to court.
Well, my lord, that's certainly not how I read the judgment, which is why I showed you paragraph 3, which talks about the husbanding of legal resources in the future, and how matters should be managed in the future. And my submission is what the court, when Justice Buxton is saying there, is giving some indications about how claims of this kind should be addressed in the future, not simply these claims.
Sorry, which paragraph is that?
Paragraph 3, Lord.
But then, if you look at 33, we return to these general observations when we discuss how relations between the parties must be conducted in the future. And then
you can see by 46 it's talking about these parts,
these parties.
because it says the judge suggested that we respectfully agree, and then later again it refers to what the we and the judge have suggested. So it's
Yes,
only referring to these parties.
Well, certainly, I read these passages, and if anything, the passage in 47 and 48 is put rather widely. They were suggested to be how parties ought to approach this in the future, and I saw that at 48 there's reference to coming back to court or to this court, which seemed an unlikely eventuality on the facts of that case in relation to those parties in that case.
This was decided in October 2006,
That's right, I think.
by which stage the provisions we've been looking at had been in force for some 13, almost 14 years.
That's right.
So if you're right, what they should have said is not this is how they should be dealt with in the future, but the Act says that these must all be arbitrated.
I recognised, I draw attention to this, that the question of arbitration was simply not before the court on litigation. Nobody focused on it. So
But
arbitration.
in that respect, it's per incuriam. The court were just unaware, you say, that actually there was already a statutory provision which required all these claims to be
and there's
arbitrated.
evidence of this. Nothing in this.
But that's right, is it? I mean, that is the effect of your submission, that this was per incuriam, because actually, if they'd been properly informed, they would have realised that there was already a requirement under the existing statute that they had to be arbitrated.
In that sense, that is right. But the point, the sole point I make this to is not to suggest that this in any way suggests that these claims have to be arbitrated. It simply is this court on a previous occasion reinforcing the underlying policy reasons for ensuring that claims such as this are determined in arbitration. And we say those policy reasons do apply under 82(1)(b), and it's what Parliament had in mind on our construction of 96(3). And I recognise that that's at the very heart
I
of the
understand
debate.
that's why you're referring to it, but I'm pointing out that it may cause you a little difficulty. We don't often assume that members of this court, certainly those who are familiar with construction work, which that constitution included, are unaware of and would not have taken notice of the relevant provisions when they are specifically addressing the question of what is the proper jurisdiction in which claims should be brought.
Well, my lord, the whole question of whether arbitration applied was not a live issue in
I
those
understand that's your
proceedings.
submission.
No submissions appear to have been directed to the issue at all. Certainly nothing we see in the judgment. And indeed, as far as one can see, the statements we've seen come from the court wishing to provide guidance as to how, in future, disputes of this kind should be
And
resolved.
there are two possible explanations as to why it wasn't raised. One is that your argument is wrong and no one thought of arguing it. And indeed, the court, it never occurred to the court that your argument was right. The other is that everybody overlooked it. And I think your submission is the latter.
Well, it's not so much that everybody overlooked it. We would say it simply wasn't before the court. It wasn't a live issue before the court. It was the court who, of their own motion, it would appear, made these suggestions as to how in the future things would develop. And yes, it is part of my.
Sorry, when I say everybody overlooked it, I understand that point. It's the court who's overlooked
it's
it
more-
rather than the parties.
Indeed. So it's more that
Well,
Lord Justice Buxton and those who contributed to the judgment did not have in mind, did not consider. And that is a necessary part of the point I make now, yes.
Well, the third explanation is that the parties and the court, to the extent they thought about it, thought that Section 82(1)(b) was expressed as a entitlement to compensation, that there was no express requirement of arbitration, and what they're suggesting is that the parties nevertheless should arrange an ad hoc arbitration before a single engineer, which fully meets your submission that in any event it's sensible that these matters are arbitrated rather than litigated. And the court recognises that by saying this is what the party should do, and if they don't, they'll get short shrift.
Well, I showed you this passage solely because it reinforces the purposive policy points that I make. My submission is the court was not engaged with and did not engage with the question that this court now has in front of it. And you cannot gain any assistance one way or the other on the question before you from the way in which Lord Justice Buxton expressed himself. But that's my submission, and we do say that it would not be safe to assume that something other than what was expressed was actually in people's minds.
I mean, these particular cases may have been what you would describe as vanilla technical quantum only cases, but there may be issues under Section 82, including 82(1)(b) claims, where there are difficult questions of law as to whether the circumstances in which the right to recovery arises because of an invocation of an argument that it was caused by a person for whom the claiming party was responsible. And that may raise questions of fact and law on which an arbitrator has no very good claim to be better qualified than
Well, it is certainly possible, my lord, that claims may arise which engage with the, I think, subsection 4, and therefore give rise to issues other than simply were the events engaged, what's quantum. It's certainly possible that will take place even under 82(1)(b). And in those circumstances, one can see that there may be more in play, may or may not be more or less appropriate for a different forum. I recognise that, but we do say that in relation to each of the, there's a sense in which we have here a recovery of, in essence, the Parliament has expressed itself.
But it really goes back to my Lord's point that the court in this case was saying the kind of cases they were dealing with ought to go to arbitration. That doesn't support an argument from a purposive construction that all Section 82(1)(b) cases ought to go to arbitration, and that's why you should interpret 93(3) in that way.
Well, the Yorkshire electricity case was in fact a case where it was being suggested that the third party's actions had somehow affected liability. That was the essence of what that dispute was about. Court of Appeal didn't seem to find that either particularly difficult or complicated and make their comments in relation to how to proceed going forward in the light of that. But I recognise that at least in theory, you may occasionally get, and it would be very occasional cases which are give rise to issues which are more than, to use my Lord Justice Popplewell's expression, vanilla. Now let me come to, we spent a lot of time this morning already on the proviso and what it means. I'm going to, therefore, I can take this part of my submissions much more quickly on the basis that we have already covered it. You have my submission that the proviso is intended to make clear categories of disputes that are not within the first part of the section. We have looked at the other categories to which section 96(3) does not apply. We've covered that. I've made my submissions as to why they, that is to say, section 75, 74, insofar as my learned friends suggest otherwise, and 78 do not fall within it. And I've made my submissions, I think you know what my submission is in relation to the question of then how one approaches the question of a right to compensation is, we say, affected by context, and the context is a context in which the other, I can put it this way, bedfellows in the proviso are not provisions that would otherwise fall into 96 subsection 3, that's the submission. And if they are not, that would be a good reason to look at right to compensation, at least as not within it as well. I've made the submission about the compensation, that right to compensation is not an expression we find used in the statute at all. It isn't a defined term. We are therefore, in my submission, driven back to its ordinary and natural meaning. I think I've already indicated, and I don't need to go back there, I don't think, that its ordinary and natural meaning ordinarily covers something which is to do with something that has to be paid to make up for a loss that a man has suffered, I think is the language I took from one of the cases in Skeleton. I wasn't, unless your lordships wanted me to, going to go back to the instances where previous courts have talked about the ordinary and natural meaning of compensation, partly because you're perfectly well equipped to form that view yourself, my lords, but also partly because I recognise that in the end, the expression right to compensation will, the expression is sufficiently flexible that it will be influenced, it will take its colour from its context. But you know the passages I refer to, they're in my skeleton. And we do say that a right to compensation therefore means something different to a claim that otherwise would fall within 96(3). We say what it means is, rather like natural meaning, those circumstances where there's provisions which give the power of a party, enable a party to recover loss and damage, if I can use the expression, at large, more generally. And there are such provisions that exist in the statute. Perhaps we've identified three, perhaps just worth looking at them briefly. It's at page 70 of the authorities bundle, section 79. I can't immediately remember whether we've already been here today. These are provisions to do with undertaker having to keep records of where apparatus is located. And the relevant parts are, you see the substantive obligation in 1, 2, and 3, and then 4, in the event of a failure, liability in relation to criminal liability, and liable to compensate any person in respect of loss or damage incurred by him in consequence of failure. So that's we say, a provision in respect of loss or damage generally, rather than specifically in relation to recovery of expenses. And my lords know that that's the distinction I seek to draw. So that's one example. Another example is section 84. Page 78. '84 relates to measures necessary where apparatus is affected by major works. Subsection 1 requires effectively the relevant authority, highway, bridge or transport, and the undertaker to take particular types of steps. And we see at subsection 3, any dispute between the authority and the undertaker, as the matters mentioned in section 1, shall in default be settled by arbitration. If they can't agree upon or settle upon a regime, that goes to arbitration. But then at 4, if the authority fails to comply with an agreement between them as to any of those matters, that's the subsection 1 matters, or with the decision of the arbitrator on subsection 3, so whatever the arbitrator has effectively told the parties must do to meet their section 1 matters, well then the authority or the undertaker, so either, shall be liable to compensate the other in respect of any loss or damage resulting from the failure. So again we see loss or damage being defined at large. Recognise the verb compensate has been used again. And that's where we see, so compensate is living happily with the concepts of loss and damage, and that's what we say gives an indication as to what a right to compensation is. And the other candidate is the one we've already looked at, my lords, and we've been over this. So this is page 75, section 82(1), A, where, as you know, I say that 82(1)A is also of a similar kind to the other two, and is therefore rightly regarded as a right to compensation. And
Can I just ask you, sorry,
yes,
because you looked at 79, can I just quickly look back at that?
please.
So that's where the undertaker doesn't keep proper records. And then he's, under 4, he's liable to compensate any person in respect of loss or damage incurred by him in consequence of a failure. So the one undertaker has got some apparatus in the street, and because there isn't a proper record kept, someone else can claim damages.
Yes.
And that will be someone who's got authority to execute works by the look of it.
Well, it's not on the face of it limited to that. It's anybody, any person in respect of loss or damage incurred by him in consequence of the failure. So one example may involve somebody who's executed works and as a consequence, for example, become liable to somebody else as a consequence of the fact they were unable to avoid an apparatus which should have been.
Well, they dig a hole in the road and,
Yeah.
and a gas explosion happens because there wasn't a proper record of where the gas pipe was. It's an obvious kind of example.
That might be an example, but
But it might be also something where because the record isn't properly kept, there might be someone else might have to, because the road explodes, someone else may have to spend money, including the street authority, may have to spend money rebuilding the road.
yes, but it might also apply in circumstances where outside the scenario of an explosion or even works, in that somebody may have to go to considerable additional cost or whatever in order to carry out work or incur other liabilities, or perhaps incur liabilities to third parties as a consequence. So
But that then
it's
fall
not
within...
limited to...
Sorry, I'm so sorry.
I'm sorry.
No, I cut you off. You finish your
I'm
sentence.
saying it's not, in my submission, limited to loss and damage incurred in the execution of works by a person, although one can see that it would include that.
Right, that was my question.
Yeah.
So if in those sorts of cases, that could give rise to a right to recover costs and expenses incurred in executing works or taking other steps.
Well, it would certainly give a right to recover such loss and damage that has arisen in consequence of the failure, and that could include just that. I don't dispute that. That's back to effectively the same point that was raised in relation to 82(1)A. In theory, the loss or damage could either be assessed by reference to the costs expended, or could be the costs expended. I don't dispute that.
An electricity company doesn't keep a proper record of where it is. Some works are done. It interrupts the electricity supply for a local factory owner. They hire a generator to keep their factory going, and they claim the cost of the generator. That would be a valid claim under this.
On the face of it would. I wouldn't dissent. Indeed. So it's quite wide in its scope, and deliberately wide. And one of the reasons why we say it can be legitimately looked at as a right to compensation is its breadth. But I understand the point, my Lord Justice Marks put it, which is that it can, in some circumstances, also be limited. I follow that, but in a sense, that's a point which I've covered in relation to other provisions, and my answer would be the same.
Right. Sorry, and then you were going to go back, I think, to 82, is that before I interrupted you?
Yeah, 82, well, I was going to go to 82, because my third example was 82(1)A, I think we covered that ground. So I was going to say no more about that. That's in my submission. That's another example. We say these are all instances where a right to compensation refers to something, a more general right, not limited to the claim in respect to recover. You have has recover expenses incurred, and we I've covered this ground as well. But we do say that it is hard when one looks at 96(3) at the opening section to see how that can legitimately encompass all of the claims that could be brought under Part 3, which, as I say, is my own friend's position, was the judge's position ultimately. But we've covered that ground as well. So I need now to come on to, well, the question I think is why is the verb compensate used in 82.1, and what is its effect? Now, my submission is the use of the verb, and in a sense we have been around all of this, so again I'll take quicker, but I'm keen that my lords know what my submission is. My submission is the use of the verb alone does not change the substantive effect of A or B that follow it. They are distinct claims capable of being brought by different parties in different circumstances for different relief, in the sense that B is limited to the recovery of costs and expenses incurred in making good damage.
This is the key point, isn't it? Why do you say that the recovery of expenses incurred in making good damage isn't compensation?
Well, it's no more
because
or
on
less.
an ordinary sense it is.
Indeed, but in an ordinary sense, that could be said of every provision where there's a right to recover expenses which have been incurred.
But that's why the key thing is the use of the word compensate.
And so there is a sense...
Which is exactly what is the defining expression in 96.3.
And we say that the use of the verb compensate does not mean that a provision, so perhaps let's put it a slightly different way so that I can be as clear as I can. If the verb compensate was not used, say a perfectly reasonable synonym, I submit, would say shall be liable in respect of or liable to, well then, if that were in, it would not be possible to suggest that...
Because 96.3 expressly says that if it uses the term liable, then it is within the first part.
Yes, but we see the word liability at the beginning of 82, we see the word liability used at 82.3 and 82.4. Liability is used as an expression within 82. So, take it some other, shall pay, shall be responsible for, some language which is not otherwise within 96.3.
Anything other than compensate.
Well, but certainly...
Which is what section 93.6.3 tells us.
But then we come back to, one looks at, in my submission, you look at the substance of what follows it. Is the substance within or without 96.3? And you have my submission on why we say the substance of B is squarely within the first part of 96.3. The substance of A never was. They are two distinct and separate claims, and the use of the verb compensate doesn't change that, doesn't suddenly give the whole thing a different meaning.
It might be said, if you just look at 96.3, everything within the first sentence does involve a right to compensation. But that's why, when you come to the second sentence, it doesn't exclude rights to compensation, it excludes provisions expressed as providing a right to compensation. Because everything in the first part is easily as a matter of natural language, and as you put it, a matter of substance, a right to compensation. So when you then apply the second sentence, it can't be done by reference to the substance of the liability. It must be done by reference to the expression of the right or liability.
Well, the fact that you could label, if you wanted to, everything as compensation does not, in my submission, assist in understanding what's meant in that first sentence. If the first sentence the Parliament had meant were in any provision, any party is entitled to claim sums of money, recover, seek relief, and it would have said that.
Well, it does. It says
If it meant it to be
recover,
broad, it
recover
could and would
costs
have
and
said that.
expenses. That's a form of compensation as a matter of substance.
Well, yes, it is a form of compensation, but why keep it? Why use such precise and narrow language if the intention is to keep even claims which cannot be properly characterised? And in my submission, we looked at one or two of those as under provisions which entitle a party to recover costs or expenses. If the intention had been to put it in that way, why use that formula at all? The formula is intended, in my submission, to narrow the scope. And that narrowing of the scope informs that which follows. But I fear we're covering ground I've covered. But
Can I ask you another aspect?
yes, please.
Do you accept that you have to overcome one other hurdle, in that it seems inherently unlikely that the legislature would have enacted a scheme whereby two limbs of matters which are described as shall compensate, A and B, in the same subsection of one section, had effect that one would be subject to mandatory arbitration and the other would not, without in any way making that, on any basis, making that clear. And that would be an odd statutory drafting, wouldn't it?
Well, if the my lord, if one sees section 82 as providing for, and in my submission this is correct, two different types of claims by two different parties. One essentially brought by a street authority, another by any other person. So there's no world in which an 82.1a claim and an 82.1b claim could ever be brought by the same party. They are different parties, different claims by different persons.
But all it's doing, isn't it, is saying that effectively that the street authority can recover all loss and damage, whereas any other person with apparatus can only incur that their compensation is limited to the expenses reasonably incurred in making good. So they're the same claims for the same sums initially, but the street authority can go on and claim more.
Well, I don't accept they're necessarily the same claims at all. They may be very different claims in their character. A claim brought by the street authority could be for something quite different. They're entitled to loss or damage as a result of the execution of works, street works. And that loss or damage does not have to be in any way defined by damage to apparatus. In fact, the street authority may have no apparatus, or may have limited amounts of apparatus. In the street, it's much more likely to be an undertaker's apparatus. So I don't accept they're the same claims. In fact, my submission that they're quite different claims.
Well, they may be the same, but they can be wider.
There may be scenarios in which the same, but it's my submission it's not likely they'll be the same. They are likely to be quite different. In that one is the so-called strike claims are claims by an apparatus owner who has to execute works to make it good, and he's entitled to look to the other undertaker for the cost of that. Whereas the street authority could be making a claim for any number of different reasons, but it's very unlikely to be because its apparatus in the street has been damaged by another undertaker. Because street authority typically will not have apparatus in the street. That's undertakers.
But at the end of the day, it still comes back to it. You have a subsection which starts with shall compensate and then provides two examples. And one of them, it falls within the rubric expresses a right of compensation, and the other is deemed to be not expressing a right of compensation. And that just seems extremely difficult and strange drafting.
Well,
Very strange way to do it. With a very significant difference in outcome.
well, difference in outcome in terms of where those different types of claims would be dealt with as its natural form. That's definitely right. I make the submission that there will be different claims by different parties. So although it may look to the eye striking, but actually
they will be by different parties. They may be different claims, but they may be identical claims, materially identical. I mean, you make the point about a street authority not suffering damage, but speaking for myself, the amount of street furniture that I see nowadays means that it doesn't strike me as wholly improbable that a street authority might have a claim for the cost and expenses of replacing the street furniture.
Well, yes, I'm not.
But there we are.
Yes, and in the end, the question I recognise, the question that's being asked is really why on earth did the legislature use the word compensate if it all means what I say it means?
But can I approach that from a slightly different angle? The draftsperson is in 96.3 decides that whether it's a carve out or not, they need to say that certain compensation claims are not going to be arbitrable, and the way they've chosen to do it is to say to make clear that anything which is expressed as conferring a right to compensation is going to be taken out of the arbitrability category. Now, whether they've already dealt with the drafting of other sections before or not, one would expect the draftsperson at that stage to go back and say, well, which of the sections are expressed in terms of conferring a right to compensation? And there aren't very many of them. There are two of them which use the language of shall be liable to compensate, and there's this one. And if they really did not intend to make clear that 82.1b was excluded, one would have thought they would say, well, wait a moment, the way that 82.1 is drafted is expressing it as compensation. We don't need to. We could actually rejig it so that we say 82.1 says an undertaker shall compensate the street authority, etc., etc., etc. And 82, a new 82.2, as it were, deals with other people other than street authorities and doesn't use the language of compensation at all. It may only be the same way of putting a point, but there aren't many references to compensation, and this could have been expressed in the way you suggest it is to be read, without having the word compensate govern 82.1b. But the draftsman has been, in your submission at least, foolish to leave room for an argument that it does.
I recognise we've looked at the other two, where the word compensate. I don't think compensation is used, but
it's not in any of them. The other two are liable to compensate, and
Indeed.
This is shall compensate.
Indeed, so compensate is used.
Compensate is the word used in each case, not
Indeed.
compensation or a right to compensate.
Indeed. So yes, my submission is that compensate has been used. It's been used because it's apposite for A, but actually it's not apposite for B. It never was apposite for B, and it can't change the actual content of B.
Well,
The actual content is get by reading.
I understand that.
You understand that?
I thought I should raise it
No,
in
but
case you wanted to say anything more.
Yes, that's and in a sense, I suspect, my lord, I have covered all the ground that's likely to assist you. And I'll just check to see if anyone disagrees. unless I've got anything I can assist you with further, those are my suggestions.
Thank you very much. I think we'll rise for a moment to see where we are.
All rise available.
You're off the hook.
Well done. Well danced.
Sorry?
Well danced.
Yeah, it was absolutely. Well, you can see it very clearly. And when it's you can see half the
What's your point?
I was wondering if they were to come to a conclusion that a claim could be brought by a local authority under section 82(1)(a), if it was very narrowly constrained to a recovery for loss and expenses of making good the damage. Like substantively, if they were narrowly required to constrain their claim in that way, you could make. And we would be
Are we being streamed at the moment?
Excuse
we are
me?
being streamed.
Yes.
The streaming is on, so
Yeah.
always a good idea. Bear in mind.
I think that it's worth. What's the answer to that?
Let's discuss it. One by one. Sorry. Their point is, it's all excluded. So they're not in it. She's obviously not in it. Do you want to see if we can encourage the others? They're not here.
Just going to get them,
I think we'll come out again. Come back.
I'm going to send a message. Wait. It should be a second. Oh.
A specific question.
Is everyone here? All rise available.
Mr. Lill, we don't need to hear from you. That will therefore conclude the hearing. We'll give you our decision, which won't come as a surprise in the light of that, but our reasons in due course. Judgment will be reserved. You know the form, you'll get it in draft. It has the embargo on it. All those who receive it will understand how seriously that embargo is taken and the consequences, including potentially contempt if it's not complied with. Returns, please, in the form of typographical or other administrative errors, not, of course, an opportunity to re-argue the case. If you can agree an order, please submit an agreed order. If you fail to agree, then give us your rival submissions in writing and we'll determine them on paper. And as usual, there'll be no requirement for anybody to attend at the hand down.
My Lord, may I raise just one point?
Yes.
In answer to one of the questions raised on section 78. My learned junior diligently researched whether there had been any regulations prescribed, and apparently there are not. So perhaps is a moot point, but section 78 refers to regulations that may be prescribed. I understand that they haven't been.
No, well, the argument probably turns on regulations which could be prescribed rather than those which have been. But thank you very much for that information. That concludes the hearing. Thank you.
All rise,